We're doing this month. We're doing life estates. We're talking about life estates with Eric Correira from Correira Law in Swansea. Eric, do you want to say anything about your practice?
Sure. I'm a estate planning and elder law attorney. I have an office in Swansea, Massachusetts, as well as a few other locations in Massachusetts, Rhode Island, and Florida. And I practice in all three of those states exclusively trust and estate law, including elder law.
Okay. And after we scheduled this, we determined that neither Eric nor I really like life estates. So this webinar is going to be somewhat slanted against the idea of using a life estate. Although there are positive reasons to use a life estate. It works for some people. For some people, it doesn't work. So let's get started. How does a life estate work, Eric?
Okay, so a life estate is, just kind of boil it down to the basics, is a real estate interest. So you have a deed where someone who owns a piece of property conveys that property to one or more persons and retains a right for the rest of their life to occupy the property and essentially live there. That's the life estate. The most typical scenario is a parent that wants to make a transfer to a child or children. They deed the interest to the children and they're the life tenant. They have the right to stay there. Technically, a life estate can be based on the life of another, but I don't think we need to go down, that's like sort of law school. I don't know.
Yeah, I have the right to live there based on someone else's lifespan. Right. That's very rare. The remainder persons, the remainder men, are the people who you deed it to. Now, they have a vested interest. When you have a life estate, you have the right to live there, to use it, to rent, to collect rents. But the people who are inheriting are locked in. And even if they die before you die, before the life tenant dies, they own something. So it can flow through their estate to somebody else. But you could do a deed. Let's say you have 3 children. Let's use the example today of 3 children. You can deed it to them as tenants in common, or you can deed it to them as joint tenants with right of survivorship. Now, if it's joint tenants and one of them dies, the other 2 have it. If you deed it as tenants in common and one of them dies before you, then we got a floating third out there that's got to go through probate. So this is a vehicle that does work for some families, but doesn't work for all families. And I think by the end, we're going to be talking about trusts and other ways to transfer property. So what are the rights of these remainder persons, Eric? I think we got you down for covering that.
The rights, if you look at a life estate deed, the rights of the remaindermen, they have a property interest. While the life tenant's living, that person's responsible for the maintenance, upkeep, the taxes, basically everything about the property. They can't cause the property to fall into disrepair, right? The legal term be waste. So the remaindermen are sort of just sitting tight. Their interest can be conveyed in the meantime to some other person. They could, in theory, sell it or incorporate into their own estate planning. But that's really it. They own it subject to the life estate.
But they don't, they can't really do anything. So if the person is just letting it fall apart, the life tenant, the person with a life estate is known as a life tenant. If that person is letting it fall apart, they could potentially file a lawsuit.
Right.
Because sometimes that's the stepmother who's taking care of who's living in the property. But it's kind of a mess. It's a trust in this case would be a better vehicle because it provides all sorts of legal rights through trust law. But it's a vehicle. That's about all we've got to say. I mean, I don't think we don't really like it a lot. So what does it do? What's the benefit of a life estate? Well, first of all, the reason a lot of people do it is it avoids probate. you've deeded to your 3 children, you've kept the right to live there. You don't feel like you've lost anything because all you wanted was the right to live there. And when you die, there's a death certificate recorded and then they own it. All right. Now, there's still an estate tax as though you had not given it away. I know this is not I don't think this is on our outline, but it came into my head, so I'm going to talk about it. A life estate is the right to use it. And if there's an estate tax in Massachusetts on everything once you hit $1 million in assets. And even if you don't have $1 million, there's automatically an estate tax lien on property in Massachusetts when somebody who owns an interest in real estate dies. So you got to get rid of the estate tax lien before you can do anything if you're one of the remainder persons.
But but that's intentional, right? Because most people who are doing life estates, if that's the planning, they more than likely are below $1 million in assets. So on one hand, it will be included in their taxable estate. But if they're below $1 million in Massachusetts, then there's no tax to pay.
Right.
But the good thing about that, on the flip side, is because it's part of their taxable estate, they'll get a step up in basis for income tax purposes. So they're, in other words, I guess to say it more succinctly, if they, somebody paid $50,000 for a property 20 years ago and now it's worth 200, if they do a life estate deed and they die, their children, or we're using the children as an example, if they go to sell, they'll use the $200,000 value on the date of death as the starting point for calculating a gain or loss, as opposed to the $50,000 original value that the person paid way back when. So it's includable in their taxable estate, but usually that's intentional to get the step up in basis.
Right. Now, if a married couple deeds property out with a joint life estate, then there'd be a step up. It would be treated as though each spouse owned half. So when one spouse dies, there'd be a step up in basis on half the property. And then when the second one dies, there'd be a step up on the other half. So you could wind up with some capital gains taxes there based on if the one spouse died much earlier than the second one. There are other benefits, others like senior tax breaks. I think you're going to cover that. Eric, go ahead.
Right. Well, there's you retain senior tax breaks. So one reason to do a life estate deed is it's a way to move the property interest to get potentially that probate avoidance, or we'll talk about it a little bit, Medicaid protection. But because the towns if you keep that life estate interest, you'll still be eligible for whatever tax breaks might be available for property taxes. But like we'll talk about later, that could also be done for irrevocable trust.
So I think we talked about most of the advantages of a life estate. Now, there are disadvantages. So let me start with mass health. If you deed your property away and keep the right to live there, you've protected the property, but you still have an interest in that real estate. And your life estate has a value. If it were sold, the IRS has tables that show how much you're supposed to get. Now, if it's sold while you're alive, mass health, those assets would go to you, and that would, if you were in a nursing home, those would be your assets. Estate recovery is the process where mass health comes back. It's called picking over the bones of the dead in some articles. After you die, mass health is known as Medicaid in most states. What's it called in Rhode Island? Is it called Medicaid?
Just called Medicaid.
Just called Medicaid.
Right.
Okay, so
everyone refers to LTSS benefits, but it's just Medicaid.
Okay. So estate recovery can be expanded by the state legislature. Right now in Massachusetts, they can only go after your probate estate, and the life estate deed has avoided probate. But the estate recovery law could change, and if it changes, then then the agency could file a claim for reimbursement for your mass health benefits against your life estate. Unfortunately, though, I was involved in a case with the Supreme Judicial Court called Daley a few years ago, and the court put in a footnote that was very strange. And it essentially, I think it essentially told us that they could go after the entire property, even though you gave it away and you just have the right to live there. It looks to me like our top court said, if we change the law in this state, they would approve of the state agency going after the entire property. So nothing would have been saved if this law changes. I don't know if they got that right. I think they were pointing to a case in out in the western part of the US. I don't think they actually analyzed everything right, but it's there. There's a warning shot across the bow there that if the law changes, a life estate deed may not work. So therefore, when I do a deed that's for mass health purposes, when I put a life estate in a deed, I deny that it's a life estate. Unless somebody really needs the senior circuit breakers, the tax breaks, or anything like the elderly abatement that they might get on the real estate taxes, I put in there that this is not a life estate. It will have no actuarial value. That's the number that they go after typically on estate recovery. I deny that you have any right to collect rent or to mortgage the property. I try to make it a bare right to live there so that if something happens in the future, we got a fighting chance at saying this is not a life estate and you can't come after the whole property. So what are the disadvantages, Eric? Creditors.
Creditors are a disadvantage, but before we talk about creditors, something that crossed my mind, because I think this is actually the biggest disadvantage that I see is on the capital gains tax side. The ideal situation with a life estate is person creates the life estate and they hold that for the rest of their lives. And then when they pass away, the children get to step up in basis for income tax purposes, and there's no probate. But what if the property is sold during the person's lifetime? That's actually when I have clients come in with life estate issues. That's usually the top issue I see. Imagine primary residence, they did the life estate because they wanted to protect it from the nursing home and avoid probate. But now they decide to downsize and sell their house. Well, we talked about at the beginning, these interests, the life estate interest and the remainder interest are two separate property interests. So if the parent goes to sell, their life estate interest will qualify for the principal residence exclusion. They won't have to pay tax on that piece. Of course, on the flip side, it becomes theirs and it's going to be available if they go to a nursing home. But even worse than that, for the remaindermen who usually don't live in the same house, it's not their principal residence and they would have to pay capital gains tax on the sale. So one thing that I do, I probably do this a handful of times a year, depending on if the situation's right, I'll actually have people come in with life estate deeds and have everyone involved convey their respective interests into an irrevocable trust, so that then down the road when the house is sold, but we'll talk about trusts in a little bit, but that will get you'll fix it really, and not have that huge tax hit for the remainder. So that's another downside, is just the way the income taxes play out and losing the principal residence exclusion for a good chunk of the value of the house, the part that belongs to the remaindermen. Creditors an issue. I think we've probably both seen this before. Life tenant conveys the property to a child, and then the child has problems, right? Whatever they are, they get sued. They file for bankruptcy and forget to tell their bankruptcy attorney that they own their parents' house, essentially. That's an issue as well, because again, if they don't live in the house, they're not going to be able to qualify for homestead. And so a parent may find their own home subject to their child's issues, creditor issues. So there's a lot of, it's one of those things, it's so easy to do, but it just opens up the door to so many potential problems.
So I guess that's a good place for me to talk about what I do as an alternative, because for that reason, I don't like life estate deeds. I do a deed that has what's known as a special power of appointment in it. It's sometimes called a limited power of appointment. So you deed to your three children, but you keep the bare right to stay there. It's not a life estate. And you also keep the right to change it. So what if one of these kids becomes disabled along the way? Or what if they get sued? You can move it. You could, so let's say they have a sibling that will take care of them. You could give 2/3 to one sibling. You can adjust later on if something changes. And let's say you want to go and get a reverse mortgage later on and one of them's balking at it. Take that one out and just give it to the other two, and the other two can participate in whatever you want to accomplish. So I think a power of appointment gives you some flexibility to adapt to changes, because a life estate deed is like a will that you can't change. So, and the circumstances change in the life of your children, and
Right. I mean, right. To building on that point. I mean, even just forget about creditors and children maybe being on benefits. Just the more basic. Hey, I stopped liking this kid. We had a falling out. Unless they agree, they're still going to get your house because you already conveyed it to them.
right. And I had one case that after mom died, went to the five kids didn't get along, and two of them wouldn't sell. So we had to go through a process called partition. Well, mom needed money to stay at home, and two of the kids would not help get a mortgage she needed just a little extra money every month. Now, but she had deeded it away early. They didn't want to help. They had their inheritance locked in, and that's all they cared about, it seems. So, can you obtain a reverse mortgage with a life estate deed? I think that's yours.
I
you
think
can.
you can, as long as everyone agrees, the life tenant and the remainder. But now I would say you can get a reverse mortgage, but okay. But on that point, from my perspective, people who are doing life estate deeds are trying to protect the equity in their house from Medicaid. Usually if you get a reverse mortgage, you're going to consume the equity in retirement. So I personally have never seen a situation where somebody was simultaneously doing a life estate deed and then also getting a reverse mortgage. Usually it's, hey, I'm going to use the equity in my house to live, or I want to protect the equity in my house for my kids.
It's usually one or the other, but the problem with the reverse mortgage is if you go to a nursing home, the house has to be sold. So if there's any remaining equity, that you've essentially wound up on private pay to the nursing home.
Right.
So, I mean, it might make sense before doing the reverse mortgage to deed it away, so that if there were a required sale during your lifetime after you leave the house, then the rest of the proceeds would go to the children and not to you. So it's like the thing about planning is there's no such thing as one size fits all.
Right.
And sometimes something that doesn't make sense generally would make sense in one situation. So I guess we're left now, Eric. We got plenty of time. We got 9 or 10 minutes left, which is rare for these webinars. You wanted to talk about Ladybird Deeds.
Right, we didn't touch on. So one thing to bring up, and you actually, what you described would be a sort of a modified version of a Ladybird deed, but in some states you can't do it you could do it in Massachusetts, but it wouldn't provide Medicaid protection. But in some states you can do a type of sort of, I guess someone might call it an enhanced life estate deed. You can do a deed where the individual conveys the real estate, but retains the power to sell, to mortgage. There's a power of appointment to change the remainderman. And Mass Health is going to just consider that fully available to the life tenant, the individual, because they have that ability, they have full control. But in some states like Florida, you can do a Ladybird deed, and it would protect the real estate from Medicaid. Of course, in Florida, homestead protects your house from Medicaid. So they're probably, the primary residence was okay anyway. It would be for secondary residences. Rhode Island even allows Ladybird Deeds done before 2014. They're sort of grandfathered in. They changed the regulations, but it wasn't retroactive. So there are, anyone who comes across a Rhode Island individual, just know that just because you see a Ladybird deed, its treatment in Rhode Island would be different than in Massachusetts. So this is definitely a state by state issue. Are Ladybird deeds any better than life estate deeds? I don't know. It's just maybe a little bit. But on the flip side, I've always heard with Ladybird deeds, there are some title companies that don't know how to treat them, and you can run into issues because of those retained rights. It's almost that, a title company wants to see something that's clean, black and white, life tenant, remainder. And depending on how many powers are retained, it gets a little bit murky about what exactly the deed is.
Right. Land court, there are two kinds of registries in Massachusetts, and one is land court, and they will not accept a deed if they don't understand it. And if there's too much power there, they might not accept it. I know the deed I've described that I do, where someone has a kind of a bare minimum right to live there, that's not a life estate, and they don't know what to do with that. I mean, I've had problems with land court on that. They want to see a full life estate, or I don't know why it's any of their business to prevent you from doing what you want to do. I mean, if you want to say, I have the bare minimum right to live there, you should be able to put that in a deed. But they didn't know what to call it. They had to fit
There's
it
no
into a
code
category
on the website.
But eventually we got it through.
Okay. I mean, I've run into the same, now we're really going on a tangent, but I've run into the same issue with land court, with irrevocable trusts, with the trust certificate, because I don't know what those, these Medicaid trusts are very particular about what rights are there, and it doesn't necessarily line up with what they're used to seeing with maybe the more common revocable trust. So I've had to appease some different land courts with unique language that just to get it recorded or registered, I should say.
But sometimes they have sample language that they'll give you that they've seen it before, and they'll accept this and they give it to you.
Well, I've even had some land courts where I said I've registered this same certificate in 3 other land courts, but that's still not good enough.
All right, so I guess what we're left with, what's better than a life estate? An irrevocable trust. So before we go there, I just want to say there are times, it's not one size fits all. Here's what I don't like about an irrevocable trust. Yeah, there's a 5-year look back period when you make a gift of some sort. And if you give to people and then you need nursing home care within the next 5 years and you cannot pay, the people can deed it back to you. If you put it in an irrevocable trust, the trust has to say, we cannot give it back to you. So it puts you at risk for the next 5 years. Now, maybe there's a court proceeding you can go through to undo the trust and get the property back, but that proceeding might be more expensive than the trust itself was. But go ahead. What?
Well, maybe. Now in Massachusetts with the Uniform Trust Code, I've done a few. I mean, it's not peanuts, but it's not cost prohibitive to terminate an irrevocable trust if everyone agrees.
Right.
It's all done through the mail.
And actually, since COVID hit, court systems are being run just like this through Zoom. So it's cheaper to deal with things like this because instead of having to travel, you just sit in your office and wait for for them to let you into the room.
Right. It's made a lot of things more efficient.
So what's better to you about an irrevocable trust than a life estate deed? We've got maybe 4 or 5 minutes. There's probably not enough time to go over. And
well, I think an irrevocable trust eliminates basically all of the issues we just talked about with life estate deeds. I mean, with an irrevocable trust, 100% of the property interest goes into the trust for Medicaid purposes, so that if after 5 years, if the individual goes to the nursing home, there's no retained life estate. The family could sell whatever's in that trust immediately, and then if it's real estate, the proceeds from the sale would stay in the trust protected. an irrevocable trust is a way to protect assets other than real estate. I mean, we've been focusing on real estate because we're talking about life estate deeds, but you can, beyond real estate, with an irrevocable trust, you could put bank accounts, investments, anything really that could go into a trust can go into an irrevocable trust. So you can protect more than just real estate. An irrevocable trust is going to have a power of appointment if it's properly drafted. So if you change your mind or have an issue with someone, you can change the beneficiaries.
One great thing about it is if you just decide to, at some point, you want to downsize,
Right.
the trust sells and all the tax benefits on the sale rebound to your personal return. And then the trust buys the new place. The one thing I don't like about an irrevocable trust is I don't like money being trapped inside it. You know, because all you have the right to is the income at most when you do that. So what I've done recently is something that I refer to as an exploding trust. When you sell, if you don't reinvest within 30 or 60 days, all the rest of the money just goes out to the children right away. It doesn't get locked into the trust. Now we've freed up the money. It's not stuck in the trust. Now, it's better to do that with good families where the kids are good and not greedy. You know, because the kids might use that money for you. You can't, of course, the trust cannot say that. They cannot even hint at that.
Right.
But having the money outside of the trust, to me, makes a lot of sense, not having it locked up inside.
Well, and I think whenever anyone's doing any kind of asset protection, whether it's life estate deeds or trust, they have to understand that we try to give them as much control as possible and safety assurance. Okay, this is my house, I have the right to live there, but they are good. You do have to give something up. So whoever this is going to, whether it's remainderment on a life estate deed or beneficiaries of an irrevocable trust, hopefully they're going to be good and won't have any problems in the future.
Okay.
Because ultimately all these things are really, they don't benefit the individual who's doing it, right? Because they'll be in a nursing home or pass away.
You're doing it
It's
for
really
other
to
people.
benefit the next generation, whoever they're leaving things to.
Yeah. Well, I think one last thing, I think we talked about this before we went onto the webinar, is Mass Health uses life estate tables. If the property is sold while you're alive, the IRS has tables that are reasonable about what you should receive. Mass Health has old tables based, I don't know what it has different assumptions. For example, someone who's age 76 who has a life estate would get half of the proceeds if it were sold. So you're really not protecting as much as you thought you were going to protect. So a lot of people, when they do this, they did it away. Oh, I'm never moving. But then circumstances change and they want to move. And a lot of what they thought they had protected is coming right back into their hands.
Right. And if we're talking about their primary residence and they go into a nursing home with a life estate deed, then the family's faced with the issue of, do we sell it and lose all that protection, or because they might not want to, especially with the Social Security tables being used, then they're in a situation where they're going to have to rent the property or somehow cover the ongoing expenses of the property until the parent passes away. So irrevocable trust would avoid that.
Right. People don't want to be landlords on a property that may not have been updated.
They don't want to be right. And any profit's going to have to go to the life tenant in the nursing home. So no one's really going to benefit from it.
Right.
Right. A lot of times in those situations, I find people, if they're going to, sort of sit tight, they'll find a family member who will just move in and just their rent will be the cost, the ongoing cost of the property. Because again, making money it would just go to the nursing home.
And then I think there's one other thing we didn't mention is partition. There is a possibility that someone suing you and if you're a life tenant, can force a sale so that you can get at your interest. If the property were in the trust and you were sued, they couldn't come after it.
Right.
So So
Right. I mean, we usually do the trust for the trust we're talking about primarily for Medicaid nursing home protection, but there actually is a creditor protection benefit from doing irrevocable trust.
So all in all, we don't really like, I think we can summarize by saying we don't really love life estates. They work for some people who don't, but it's not the perfect solution. And the law could change and the perfect solution can become no solution at all, and not protect anything for mass health purposes. I guess we end on that. Thank you, Eric, for joining us. We'll do another one someday on something
Yeah, that
else.
sounds good. Okay.
Thank you.
Sounds good. Thanks for having me.
Ending. Thank you all for
Yeah.
joining us. Bye.
Bye.